To take their seats, please, so we can get the show on the road. Yes. Brain went blank. Bonjour tout le monde.
Good morning. Good afternoon, everyone.
Welcome to meeting 126 of the Standing Committee on Industry, Science and Technology as we continue our review of the statutory review of the Copyright Act. Before we get into it, we just have a couple of minutes of house duty. I'd like to officially welcome Celine. How do you pronounce the last name?
And Chavan.
Caesar
Chavan.
Chavan.
Yeah.
Okay. Welcome. You're officially a member.
Yeah. Thank you.
And on this side, both Michael Chong and Dan Albus are official members too. So welcome. Congratulations. And as such, we need to elect a vice chair.
Mr. Chair, I nominate Mr. Albus as Vice Chair for this committee.
Okay. Are there any more nominations from the floor? Well, then, I declare Mr. Dan Albus, you are the Vice Chair acclaimed.
Thank you, Mr. Chair.
First Vice Chair. Sorry. First Vice Chair. All right, we're good?
Yep.
All right, we're good.
Thank you.
All right, now that we have that out of the way, we have with us today some really interesting witnesses from the Professional Music Publishers Association, Jérôme Payette, Executive Director. From the Canadian Network Operators Consortium, Christian S. Tassett, Barrister and Solicitor, and Christopher Copeland, Counsel. From la Société des auteurs de radio, télévision et cinéma, Mathieu Plante, Président, et Stéphanie Hainaut,
Mathieu Plante, President, and Stéphanie Hainaut, who's the Executive Director.
Theatre Association of Canada, Michael Paris, Director, Legal and Chief Privacy Officer. Each group will have up to 7 minutes to make your presentation, and after that we'll go into our rounds of questions. So we're going to start off with the Professional Music Publishers Association. Monsieur Payette, vous avez 7 minutes.
Mr. Payette, you have 7 minutes. Can you hear me? So, Mr. Chair, dear committee members, this was great pleasure that I sit before you today to talk to you about this very important statutory review of the Copyright Act. The association, our association represents Francophone members of Canada. Our members control 830 publishers. We are partners with publishers and authors, and we support the creation of music. Typically, a music publishing house works with many composers for the creation of new works and represents existing catalogs of songs. Publishers are, in a way, agents of composers and their works. They are professionals of rights managements. I would like to tell you that our association is a member of the CMPC, which is the Coalition for Canadian Music Producers, which produced a 34-page brief, which I'm sure you have a copy. And we support that document. But we have a few extra issues to raise with you today. First of all, amending provisions on network services that are applied to many kinds of businesses in an indiscriminate way. Section 31.1 of the Copyright Act is the Canadian safe harbor to a certain extent. It allows the internet service providers for the telecommunications to not be held responsible for copyright infringement and to not pay copyright holders what they owe them. The current version of the law for services as various as internet access, cloud storage of data, YouTube, Instagram, and many other such services benefit in an indiscriminate way of such exceptions on network services. Yet, such businesses provide very different services. An ISP provides internet connection, or another company may allow you to store data for private use. Then there's search engines, according to keyword searches, and then YouTube and other such companies make content available to millions of users, develop user recommendations, promote content, organize content, and sell advertising to its users. So today we know that these companies do not offer all the same services. The Copyright Act must take into consideration the whole spectrum of these companies' activities and ensure that their responsibilities are not necessarily the same. I want to be clear. All of these companies should be compensating rights holders because they are using copyright-protected content for commercial purposes. But ISPs could have different responsibilities from those of YouTube, for example. ISPs, Internet Service Providers, should compensate rights holders by helping fight infringement and pirating, whereas YouTube and other such content broadcasters should be paying for the use. Last 12 September, in Europe, they did adopt such provisions. Licenses must henceforth be fair to rights holders, even for content that's been uploaded by users. Sharing services and streaming services are going to have to be more transparent about the use they're making of the content. So, users will be able to continue to upload content, but sharing and streaming services are going to have to sign agreements with rights management collectives and be more transparent. I believe Canada should be inspired by this European approach. I will close in mentioning NAFTA. We know that the U.S., at the request of major technological companies, are talking about safe harbor clauses inspired by the Digital Millennial Copyright Act. If the Canada acquiesced to U.S. demands, it would be very difficult, if not impossible, to change our own statutes for it to correspond to today's realities. Point 2, making the Private Copying Act technologically neutral and implementing a transition fund. The annual revenues for private copying have gone down for 89% for content creators, from 38 million to less than 3 million in 2016. As Marcel Boyer, the economist, said, this is the theft of the century. And it's not because it's been going on for many years now that it's become acceptable. The spirit of the 1997 Canadian statute is no longer being accepted. We have to take advantage of this statutory review to make our statute technologically neutral and allow rights to be paid and perceived on a variety of things like phones and tablets, smartphones and tablets. In Europe, they charge $2 per smartphone on average. It would be very surprising that the average phone of the iPhone 10 go from 1,529 to 1,532 just because of this levy. That levy would not be transferred to the consumer. The dramatic drop in fees perceived by copyright holders. Liberals agreed that it was more than time that such a transition fund be created in Canada. Now, as to the 50-year to the 70-year protection period, in OECD, it is 70 years. In Canada, it's only 50 years after the decease of the right holder. In Canada, exporters, of course, works are less protected than is the international standard. Canadian legislation should not act as a brake on our exports for content creators. For music publishers, which I represent, if you went to 70 years after the death of the composer, would be investing in developing other existing Canadian authors and composers. Fourth, eliminate exceptions. The number and kind of exceptions that are in the Copyright Act are depriving rights holders from revenues that they have to which they have a right. I don't have time to give you an exhaustive list, but we will be providing you with a document. And finally, 5. The importance of having a functional copyright board. I realize that things are being done in order to reform the copyright board, and I think that's wonderful, and it's excellent news. I would just like to emphasize the importance of this reform for the application of the Copyright Act. Right now, the length of time taken to make a decision are incompatible with today's rapid-paced environment. This is harmful to composers and authors and all stakeholders in the music industry. Thank you. Thank you.
Network Operators Consortium, Mr. Tassett, you have up to 7 minutes.
Thank you. Mr. Chair and committee members, CNOC is a not-for-profit industry association comprised of over 30 small, medium, and large-size competitive ISPs. At the outset, I want to stress that CNOC takes copyright infringement very seriously. In fact, a number of its members are now themselves either licensed or exempt BDUs. Our core message is that the notice and notice regime continues to strike a reasonable balance between the rights of content owners and Internet users for addressing allegations of online copyright infringement and achieving related educational objectives. However, based on CNOC member experiences, the regime does need some tweaking. More specifically, CNOC makes the following recommendations. 1. The legislation should require content owners to send notices that only contain the elements prescribed by statute. This will prevent abuse by parties who use such notices to transmit settlement demands, advertisements, or other extraneous content. 2. There should be a requirement for notices to be provided simultaneously in both text and machine-readable code. This will facilitate the choice of manual or automated processing of notices by ISPs, depending on the scale of their operations. 3. Content owners should be required to send notices exclusively to the publicly searchable abuse email addresses that ISPs register with the American Registry for Internet Numbers. This will ensure that notices are directed to the correct email addresses ISPs wish to use for processing notices. And 4, the number of notices that a rights holder can send to an ISP for an alleged infringement of a work associated with a specific IP address should be limited to no more than one notice per specified period of time, for example, 48 hours. This will prevent ISPs from being deluged with multiple notices directed at the same IP addresses for the same infringement. I will now discuss why the kind of approach advocated by Fair Play Canada Coalition, which we'll call the coalition in this submission, and other more severe measures should be rejected. Our analysis is based on a proportionality framework that includes consideration of the following matters: defining the scope of the problem, assessing the benefits and costs of the proposed remedy, and fairness. The coalition members, which include the largest vertically integrated ISPs and content providers in Canada, have spared no expense to commission and fund private studies promoting the view that the financial impact of copyright infringement on content owners is so devastating that the remedy the coalition is promoting is necessary. No other entity has the resources to respond fully to all of the coalition's submissions. Fortunately, they don't have to. In the CRTC proceeding assessing the application brought by the coalition last year seeking to implement its administrative content blocking regime, interveners such as Canadian Media Concentration Research Project, or CMCRP, and Public Interest Advocacy Center used publicly available data to demonstrate that the scope of online copyright infringement and its impact on content owners is not nearly as alarming as the coalition would have us believe. It follows that adoption of the coalition's proposed regime is not necessary. Turning to the issue of benefits, there's no point in instituting the kind of regime advocated by the coalition if it is largely ineffective. IP address blocking, domain name server or DNS blocking, and the use of deep packet inspection or DPI to block traffic can all be circumvented by various technical means, including virtual private networks or VPNs. In addition, blocking techniques can end up blocking non-infringing websites at the same time that they block infringing ones. When it comes to costs, there are both public and private ones. The private costs are those borne by parties such as ISPs to comply with the regime and the risks of litigation they bear if non-infringing content is unavoidably blocked as a result of how blocking technology works. Public costs include the additional costs of instituting and maintaining the administrative regime, as well as the erosion of legal and democratic values such as freedom of expression, privacy of communication, and avoidance of unnecessary surveillance, which are currently enshrined in common carriage and net neutrality principles. In this regard, we caution against the slippery slope of requests made by coalition members and others. At first, most of the large vertically integrated ISPs and content providers supported notice and notice. Then they embraced the coalition. Perhaps they will now argue, like MPA, that injunctions should be available against ISPs for content blocking and ISP safe harbor should be reduced. Then they might argue that the only way of preventing the circumvention of blocking is to outlaw VPNs altogether, which are used routinely to protect the privacy of security and data and facilitate freedom of expression. Content owners might even go further and argue for a notice and takedown regime without any court or administrative supervision. The costs of all these alternatives are much too high for Canadians to bear, and there's no need for any of this. The Copyright Act already provides a mechanism for content owners to seek injunctions for the removal of infringing content. The test of what is reasonable in a free and democratic society can be gleaned from a CMCRP analysis of 40 OECD and EU countries. 18 of them rarely engage in website blocking, 18 others block websites by court order, and only 4 block websites by way of administrative procedures. If, despite these submissions, Parliament does adopt the type of remedy proposed by the coalition, then fairness requires that it also allow ISPs the right to recover their costs of implementing and administering blocking mechanism. These costs can be significant and even put small ISPs out of business if the costs are not recovered. However, we urge this committee to recommend to Parliament the retention of the existing notice and notice regime with the minor modifications we have proposed. Other more stringent measures should be rejected. Thank you.
Thank you very much. We're going to move to the Movie Theatre Association of Canada. Mr. Michael Paris, you have up to 7 minutes.
Thank you very much, Mr. Chair. Good afternoon, Mr. Chair and honourable members. I'm here on behalf of the Movie Theatre Association of Canada, which I might interchangeably refer to as MTAC today, just for short. We are the trade organization representing the interests of film exhibitors behind more than 3,000 movie screens across Canada. We are exactly what the name suggests. Our members sell the tickets, sell the popcorn, and ensure that films are presented the way that creators intend on the big screen. Among other things, MTAC represents exhibitors in negotiations with collective societies and otherwise intervenes in proceedings such as this one. Having said that, we are not frequent flyers or by any means regular visitors to copyright proceedings, so we do thank you for the invitation. We're not a collective or an institution that regularly is involved in the business of copyright, although it certainly affects our members, and we do pay tariffs to certain collectives. Some quick things to tell you about exhibitors that you may not know. The first is that exhibitors, in fact, rent their films from distributors, and we keep less than 50% of every ticket our members sell. They don't control the film product they show, so if you are tired of sequels, you should take that up with the producers. And as a sector of the film industry, exhibition is more than 80% Canadian owned and operated, and it includes hundreds of mom and pop locations in places big and small. We also employ thousands of Canadians, and we're a leading first-time employer. And we are also an industry that is experiencing a great deal of disruption. As Telefilm noted in a recent study, while theaters still attract 2/3 of Canadians from time to time, Canadians are increasingly turning to streaming options. So exhibitors are competing with a universe of entertainment options like never before. So having said all that, MTAC has been historically involved in one single issue that has been raised before this committee, and that concerns the proposal from some in the music industry to amend the definition of sound recording in the Act. This is the only issue I'll speak to this afternoon, and I'll keep it very brief. In this review of the Act, a group of stakeholders led by multinational record labels and Canadian affiliates have expended considerable resources to promote the idea of a gap in the business of copyright. This group will suggest bleak prospects for creators and depicts a diminishing future where technology causes them to fall further behind if their demands aren't met with legislative amendments. And so, with respect to this amendment, they're proposing to amend the definition of sound recording in the Act to remove the exception that exists for film soundtracks where they accompany a cinematographic work, which I'm just going to say film from now on, if that's okay. The sole purpose of this amendment is to unlock a stream of royalties from the exhibitors that would provide this constituency with a share of box office revenue. MTAC believes the current definition of sound recording in the Act strikes the appropriate balance between creators, rights holders, and exhibitors. The amendment proposed by some of the music industry will aggravate the ongoing forces of technological disruption that affects exhibitors and risks further destabilizing the role of cinema as the primary showcase for Canadian creators within the domestic and global film industry. The proposal also isn't new. From 2009 to 2012, MTAC successfully responded to legal proceedings initiated by some of the music industry. In those proceedings, they argued that the current definition of sound recording should not be interpreted to contain the exemption for soundtracks that it obviously does contain. And it wasn't until the Supreme Court of Canada weighed in 2012 that this issue was put to rest. So contrary to the repeated refrain from some, the definition of sound recording is not arbitrary, it's not inequitable or unjustified. As the courts found, it was quite intentional and reflects a balance struck between creators, copyright owners, and exhibitors as drafted by thoughtful legislators. So these stakeholders are now asking this committee to pick up the pen where their litigation left off. However, the same problems identified by the courts continue to apply to this proposed amendment. So the first thing I would say is this amendment is not as simple as they suggest. It will require a significant rewriting of the Act to eliminate absurdities identified by the courts in their decisions and other inequities that this amendment would create. I don't have time to go through everything, but I will identify what I think is the most objectionable. And that is that this amendment would create a system of double dipping, where creators and copyright owners are paid on the front end for their inclusion of their work in a film, and then also on the back end when the film is played. This is exactly why the exemption was instituted, and it's consistent with how the work of other creators is treated in the Act when their work is incorporated into a film. It was never a subsidy. Neighboring rights compensate for unintended and uncontrolled usage of sound recordings that can arise without the record label's involvement. However, the right to exploit music in a film is a right for which a license is required and for which compensation has already been provided by the filmmakers. That compensation is expressly agreed upon in a contract, and the inclusion rights are negotiated directly with the copyright owner and acquired on a worldwide basis to facilitate the global distribution and exhibition rights for the film as a singular unit, not as a collection of works. This distribution model is critical to the global box office returns, which in turn pay the costs of the filmmaker, including payment to the music industry stakeholders. So that's about it, as far as I think I can go in the short time provided here today. We will be making a more detailed brief available to the committee later this week on behalf of our members. Thank you for the invitation and your time today, and I'm pleased to respond to any questions, Mr. Chair.
Thank you very much.
And finally, for our last presentation, we've got the Société des auteurs de radio, télévision et cinéma. Mathieu Plante, please go ahead. Or rather, Stéphanie Hainaut. Yes, can you all hear me? Thank you. Thank you for having invited us to appear before the committee today. We would like to talk to you today about the work of scriptwriters, and the way that Copyright Act could better enrich the Canadian economy and culture in the long term. First of all, let me tell you about SARTEC. SARTEC protects and defends the professional, economic, and moral rights of authors, freelancers they work in the audiovisual French language sector in Canada. Our group negotiates with producers, collective agreements, advises authors about their contracts, receives royalties on their behalf, and therefore contributes and helps to contribute to their work being better respected. Our collective agreements forbid the rescinding of royalties and rights, but they do grant producers licenses. for audiovisual to put to audiovisual use the scripts and screenplays of our authors, and allow our authors to thus be paid royalties through collective management rights management groups. Scriptwriters are creators who spend their lives imagining and writing the stories of our heroes and our lives. Their scripts are at the source of audiovisual works that gather people, move them, make them laugh and think, tell the rest of the world about our culture and our country, and promote our great Francophone richness. Their impact is extremely positive on the Canadian economy and well-being. But for our Canadian audiovisual production to be competitive, I believe we have the responsibility to set up, through the Act, modern mechanisms allowing our creators to be adequately compensated for the fruit of their labor. Let's not forget that to do the author of the script must be able to grant rights to a producer in exchange for compensation to the producer of a film or a theater company, if it's a play, or a publishing house for a book. It has to be able to monetize the adaptation rights for a script and to benefit from its share in its benefits. The freelance author often assumes all the risks in creating work, so the Act must allow him to amortize that risk. It must also allow our children, who have both the desire and the talent, to also dream to work one day as creators. In order to do so, we have 5 things to request from you. Today, time only allows us to give you details about 3 of them. First of all, eliminating unfair exceptions afflicting Canadian creators. We are continuing to denounce the unfair exceptions that were introduced into the Copyright Act in 2012 that are affecting our scriptwriters' capacity to continue to write our stories. But Canada needs those stories. Secondly, extend the private use copying regime to the audiovisual works. Canadian creators and producers in the audiovisual sector have been left behind in that regime, which is working quite well in other countries, including France. Thirdly, adding a co-authorship presumption in audiovisual works. The Act should specify, as per Canadian case law, that the scriptwriter and director are presumed to be co-authors under the audiovisual works for the copyright. The scriptwriter writes the text, which is a literary work, which will guide the rest of the subsequent collaborators towards the audiovisual work, whereas the director is going to make creative choices that will allow to transform the text into an audiovisual work. The script describes the film to make it as concretely as possible. By writing it, the scriptwriter is creating the story, is writing the story, describes the characters, their intentions, their behavior, their dialogues, and their evolution. He explains how the film will go, scene by scene, including its temporality, its setting, and its sound. Some even have pre-existing musical scores and write the words to the songs. We invite you to recognize that the author of the script, the adaptation, and the spoken words, and the director are presumed to be the initial rights holders on this audiovisual work. We would have no objection as to the music composer is also included in that group. Finally, we ask that the Act be modernized in order to extend the protection of works from 50 to 70 years finding the death of the author, to improve and strengthen intellectual property for audiovisual works once they have been digitized and broadcast on digital platforms. We will be providing you with a more explicit brief. In closing, allow us to remind you what the primary function of the Act is protecting the creators' intellectual property to allow them to be properly compensated for the use of their work. We believe you have the duty to encourage their capacity in the long term to continue to gather, entertain, move Canadians, make them laugh, and other people too, help them think and talk to them about our country, promoting its values and contributing to our pride by making the Act's provisions aligned with the best international practices and associating creators and allowing creators to benefit from their works. We thank you. for your attention.
Toutes les présentations.
Thank you for all of those presentations. We will begin with questions.
Field, you have 7 minutes.
Thanks, Mr. Chair, and thank you all for such concise presentations that you've prepared and delivered for us. We're here to try and find the right path forward, and your presentations are helping. But I have a few questions, starting with Mr. Payette. When you mentioned changing the copyright board, and I met with a group of musicians in Guelph recently that talked about copyright board as well. And one of their points was there should be musicians on the copyright board. Would you have any opinions on the content of the people or the construction of the copyright board, whether we should include musicians, publishers, and the range of stakeholders?
I'm not very familiar with the copyright board's procedures because mostly it's the collective administration societies that go in front of the copyright board. But to my understanding, it's mostly like a tribunal who set the rates, so it's very, very technical.
Right.
So I'm not sure that musicians should be on the board, but of course, people willing to recognize the value of the music created.
Okay. Okay, thanks. I was just wondering how deep the comment went, and so thanks for that. Also, staying with you on the share that a performer typically receives in a live performance versus a recorded performance, recorded and published performance. Do you have a sense of what kind of a gap there is there in terms of some of the musicians have said that the way to get paid now is to be live, and that payments from streaming services or publishers have dropped so drastically that they've had to really rethink the way they go to market with their product?
Well, there are different types of professionals in the music industry. You can be a songwriter that does not necessarily perform, but in the case of a singer-songwriter or that's also a performer, yes, performing has become important to make a living. And I was suggesting, concerning mostly streaming services, that we might look on what the European Parliament has just done last week on trying to get more money from the services. And I think that's very important. And what they have done is that they said that the sharing services, for example, like YouTube, will have to pay for all the streams. And right now it's not the case. They only pay for the streams that are being commercialized.
Right.
But if a user puts something online on YouTube, for example, there's no money coming out right now. But if we follow what they're doing in Europe, there would be money coming to the rights holders following I think they call it the public communication in Europe.
That's great. That's helpful. And when we consider our trade agreements with Europe and intellectual property agreements being part of that, and how we go to market in North America versus Europe, we could see that there could be an influence from the European decision. But it's a recent decision, so we haven't quite got into it, but it's really good to hear your first take on it.
I think it's a very good example to follow and give us good balance to the right holders in front of big international companies that they don't always have licenses and they don't always pay for the music that's being used.
Thanks. And you just alluded to another issue that I was thinking of was the difference between a songwriter and a performer. You think of Aretha Franklin performing Otis Redding's Respect. She didn't get paid for that. She took the meaning of the piece and she turned it on end. Instead of a man coming home and being respected by the woman, she turned it around and really changed the meaning of the song in the way that she performed it, but really didn't get paid for that in terms of the revenue stream. So the stream between performers and writers, is that something that has changed over the years? Is that something that we need to be looking at in terms of legislation?
I don't think, and I'm not familiar with the example. I know who Aretha Franklin is, and I know the song, but I think there's copyright on the song, but there's also remuneration coming out of the recording of the song. So I think she probably made money with the recording of the song. I'm not familiar with that case, but there is remuneration for performers, and I think it's normal as well that writers get paid. The people who write the songs are very important.
I guess it's in terms of interpretation of the song. But thank you for that. And it was quite the story, tragic story, losing her this summer. If I could maybe pivot over to so much to do in so little time, we've only got a few minutes left, but for Matthew and Stephanie, looking at how a Canadian author makes a living in 2018, the emerging trends on authorship, and there was a connection I could see between the cinema, the Canadian Network of Operators Consortium, the Movie Theaters Association of Canada, and the payment of music creators, music performers versus the authors that get paid for writing screenplays, writing scripts. Is there a difference there that you know of? Are they paid about the same in the same types of ways? And I could maybe follow up through Michael Paris to see whether there's agreement or whether there's knowledge that you can share on that.
Pas discuter de ces questions, cela étant.
We didn't discuss those issues. That the relationship between the scriptwriter and the movie is more fundamental than the music composers. But I understand that your question is to know whether or not we support the claim of extra compensation when the film is being broadcast. We hadn't thought of it about that, but we do agree with the fact that creators should be compensated, not only when at the moment of creation, but also proportionately for the use made of their work. And I know that it can be based on, it has to be based on the use, of course. So I think that is something that's felt across the board by content creators. We call that being associated to the economic life of the work. So if the film is very successful, and the same holds true for a television series, for example, being associated to that success should lead to increased benefits.
We're going to move to Mr. Lloyd. You have 7 minutes.
Thank you, Mr. Chair, and thank you to all the witnesses for being here today. And, we've spent many hours poring over this thing, and now that we're back from the summer, it's good to get a refresher on the issues here. My first line of questioning will be for you, Monsieur Payette. Take note in your statement. You may have heard recently that the artist Bryan Adams spoke in front of the Heritage Committee today, where he made a recommendation related to something called a reversionary right, which musicians have, wherein in Canada you have a reversionary right 25 years after your death, and in the United States your reversionary right is 35 years, and it doesn't have to be after your death; it can be within your lifetime. And I was hoping you could have a comment on that testimony and what the perspective of your stakeholders would be on that.
Well, I don't think that would be necessary to be in the law. The composers don't have to sign an assignment of rights to work with a music publisher, and actually they don't even need to work with a music publisher. And some people do their own business by themselves, and there's nothing in the law that stops what we're discussing being effective in a contract. You could say that after 35 years, the copyright would go back to the composer. So that's already possible to do if we wish to do so. And I think there's a difference between the ownership and the remuneration. And I think what's important for copyright owners is the remuneration side, and that's what we should focus on. Is how much can we give value to copyright and how much can we bring money to the music industry. And I'll end on this saying that the music publishers have catalogs of copyright that bring in steady streams of revenues that are used to being reinvested in new talent. We have to keep that in mind. That's the business model of music publishers.
So what you're saying is that based on I'm not sure if you're familiar with Mr. Adams's statement that was made in the Heritage Committee, but you're saying that there is no firm reversionary right in Canada, like it's a pretty open-ended free market system. You can give away your rights for as long as you'd like or as short as you like. It's all a negotiation.
Yeah, you can do whatever you want.
Okay, so that'll be very interesting for us to look into further. You also alluded to recent European rules related to content filters, and I was hoping, can you elaborate to the committee sort of how that impacts you as an industry?
Well, I was not referring to content filters, but what they have done in Europe, especially concerning Article 13, is that they said that it's a communication to public, even if the work has been uploaded by a user. So right now, if I put something online that's protected, if it's a user-generated content, the platform doesn't need to pay, and they don't need to have a license. So what will be the changes is that they will need to have a license and to pay the right holders, even if it's user-generated content. And they will have to be more transparent, and those companies are not transparent about what's being used, and it's the content of the right holders and the creators that's there, and we don't know what's happening with it.
Okay, so you think that would increase transparency if we were to adopt a European-style model?
Yes, exactly, and would be higher rates for the whole music industry, but all the content's online. And I think that's what they're going after in Europe, making YouTube and others pay more to right holders.
Thank you. My next line of questioning is for yourself, Mr. Tassett. There was a recent Supreme Court case related to ISP cost recovery, and I was hoping you could elaborate on the impacts of the Supreme Court case on your stakeholders and what your views are going forward.
Well, our views are that if ISPs are compelled by law to provide certain services to assist in enforcing copyright or identifying copyright infringement, they should be compensated for that fairly. The reality is that ISPs are the telephone companies of the present world. Their role is to carry content, not to question it, not to examine it. And I don't think in a democratic society we want to deviate from that very much. So if they're compelled to basically try and perform a state function, then the state should compensate them for that, or there should be some mechanism, maybe not through the state, but through the parties who have a personal, private, commercial interest in enforcing their rights to compensate.
What do you estimate the cost is to an ISP provider to perform these
That
functions?
can vary so widely because you have people who have large ISPs who have automation tools, and you have mom and pop shops that do things very manually. So the cost can be all over. I'm not in a position to tell you that, but there are some studies that were done previous to the notice and notice regime that sort of try to put a handle on the cost, at least as of that particular time period. We sort of haven't delved into that issue very much in the last few years because it was taken off the table when the government made the choice not to compensate ISPs for processing notices. So given that no regulation was passed authorizing a fee, and at that time the law was stable and the notice and notice regime was stable, we didn't at least as an association, keep delving into that. But there's probably data out there, and we could follow up with you if you're interested.
Do you view new technology as bringing down that transaction cost? Like, do you think that there's a lot of potential to basically minimize the cost to ISP
New
producers?
technology brings down costs of everything we do.
Would your opposition to this then, if the costs were brought down significantly, would your opposition to it also go down, or?
Well, the cost is what the cost is. Whether it's $10, $100, or $1, I don't think the principle is any different of cost recovery. Again, if you're being compelled to do something that ultimately is determining rights between private parties, enforcing rights, even if they're statutory rights, you should be compensated for that.
Thank you.
Thank you.
Thank you very much. We're going to move to Mr. Massey. You have 7 minutes.
Sharon, thank you for our witnesses for being here today. There's the European movement that we saw last week, but also yesterday the Copyright Modernization Act took place in the United States, where 80 senators had signed on to an agreement, a bipartisan agreement on the Music Modernization Act just yesterday. So there's those that they have the theory that there is more collaboration than ever before. Because some of the providers like Google, Amazon, Apple are actually moving towards production. So there's more of an interest from themselves in terms of protection of original content because their investments are now kind of going in that direction. The first question, I guess, for the panel is in terms of where Canada stands with regards to this. I mean, we have the European decision and we have the American decision. How do we fit into this puzzle, especially with the, maybe from the perspective of your organization with international and North American, I guess, connections in this, and where you feel that you fit in that complex changes that are taking place with Europe, but also too the United States. And if you're not familiar with the United States, particulars, will that, even if you change your perspective here at the table, once you actually understand that decision that was made for music copyright yesterday in Washington?
I think Canada is lagging behind in many ways. The term of protection is 50 years everywhere. It's 70 years in the OECD countries, in the US and Europe. Piracy is the weakest thing. Notice to notice is the weakest we can imagine. Usually it's at least notice and takedown. The rate setting for now is a good system, but it's not efficient. So I think we need to have a proper fix of the Copyright Act.
Anybody else want to comment on that?
Could I comment on the notice and notice versus notice?
Yeah, no, I'm looking for an international perspective in terms of from your organization, because you're not an island into Canada in terms of what's taking place with regards to remuneration decisions about copyright and so forth. Our European partners and our also American influence coming over here is going to have a direct correlation to your ability to actually do your work here in Canada. So I'm looking for any type of input at this, because those are dramatic changes that have just taken place. They're part of our trade agreements, and they're discussed privately, right? Some components right now with NAFTA, and as well too other trade deals. So I'm just kind of curious as to these moving parts, because we're examining it in a very much navel-gazing way here with regards to copyright through this process and review of our legislation of a 5-year review here. But the reality is the world's already moved on from where we've had our legislation passed and where we're at from even starting the study. So if you have anything into that, I'm interested to hear.
Well, as I said, I wanted to address this specific comment, and it's this. I want to make the point that I made earlier, which is ISPs are common carriers. They're supposed to be transmitting data. To start engaging them to fight infringement more proactively means this. It means that you are now asking ISPs to inject their own economic self-interest of avoiding liability into the mix of carrying traffic. That, to me, is a very dangerous proposition in a free and democratic society. So it's beyond the cost that ISPs bear, even if they could be compensated for that. I just think it's a very slippery slope, and that's why we object to all of the types of measures from the coalition on down to up, I guess, to notice and take down. It's not just about ISP's interest, it's about broader democratic values for the country.
I'll just say a quick, I know I said I was only going to talk about one issue, but I can respond to this just a little bit. MTAC is a member of the Fair Play Coalition, and we do support that initiative quite strongly. The proposal, as I understand it, and the comment earlier was that, the Copyright Act currently provides an injunctive remedy for those seeking to respond to infringement. And it won't surprise any of the lawyers in the room if I say the phrase, there is no right without a remedy. And injunctive relief is not a practical remedy, and you don't need to look very further than to find out how many injunctions have actually been granted in connection with the Copyright Act to know that, which is why the Fair Play Coalition is proposing a separate body to deal with exactly these kinds of requests. I don't propose to speak on behalf of the ISPs and what the compliance burden might be to deal with orders to restrict access to certain infringing content as identified by that body, and that's a little outside of my ballpark, but we've been down this road for 20 years talking about how to effectively respond to infringement, and I think a review of the Act and a serious long look at what the Fair Play Coalition is proposing is certainly worth doing. And I'm sorry I can't contextualize that further in the U.S. development yesterday. But I do note that this exact same system exists in the United Kingdom and in other places, and that's something this committee should look to.
Vous demandiez
You were asking what our organization's reaction was following the European Union Parliament's directive. Well, we were delighted. In fact, the whole world is rejoicing in this directive, adopted by a majority of the European Parliament on September 12th. For us, it's a model of wisdom, and it should inspire you in favor of our economy. It's favorable to our culture, but creators revenues have been dropping, even though their works are increasingly being used. It's high time we found a way to allow Canadian content creators and the Canadian creative industry to benefit from all this use of their works that's leaving the country, and yet they get nothing. So services such as YouTube must negotiate fair contracts with content creators. We should be inspired by their example. I don't know exactly what's gone on in the United States, but we're going to look at it, and perhaps we will be adding to the brief that we will be submitting to you. Thank you.
You have 7 minutes.
Monsieur Payette, je vais commencer avec toi au début.
I'll start with you, Mr. Payette. And then Madame Hinault. Is there another good where the rights go beyond the lifespan of the creator, of the owner? Because you're saying that you want to go from 50 to 70 years following the death of the author. But is there any other product in the economy where the rights are not extinguished with the person when they die? Just about everything we own is a property right. So once you die, your children inherit it, or someone inherits it. When I die, I buy a house, I die, my children inherit my house. My ownership of the house doesn't die with me. Well, it does. Answer my question. It doesn't continue to belong to you 50 years after your death, or 7 years after your death. It's transferred to your children. No, but it is still a property right. I think the Berne Convention said that the idea of a 70-year, extending the protection to 70 years, was so that 2 generations of descendants could benefit from the protected work that was, and that's what underlay this idea. So, but 70 years after death, it goes up is more like 4 generations. How do you justify that? Well, for businesses, it generates companies too. It generates revenues for companies as well, because not only individuals own copyrights, but for example, music publishing houses also benefit. Now, there's no end date copyright for all other types of property. The rights don't expire. It's only true for copyright. Well, do you have anything to add, Madame Hinault? Well, if I create something, and I have a child who has a child. So I'm now a grandmother. In 70 years is the life expectancy, is the lifespan of my grandchild. So it's as if we say to you, your house is only good for 2 generations, and after that, anyone can come and live in your house. So I would say that other countries have understood this and expanded that. So the fact that in Canada it's 50 years, it means that Canada's losing revenues, because when Canadian works are exported elsewhere in other countries where it's 70 years, the money that is collected by rights management collectives doesn't apply over there. So according to our understanding, it's not business-wise not to extend the protection to 70 years, in fact. Mr. Payette, earlier you talked about a $3 sum. Are we assuming that all users are pirating content? No. That's so. Why don't we just have a levy on all products that are being bought? Because I have 128 gigabytes here. Why should I pay for that if it's not a support for, if I can't record my music on it? Well, we're just saying that there's a levy for each piece of equipment that's purchased. This is a widespread practice across the world. Croatia, France, Hungary, Italy, Holland, Switzerland, many countries in Europe have adopted this regimen. So these are royalties. It's the same principle as the levy that we applied to CDs. We just want to continue to be technologically neutral, and I think that was the intention in 1997. And perhaps it wasn't written in technologically neutral language, so it didn't extend to other formats. Well, is it justifiable without a court order? I'm not familiar with the way it works exactly, but what I can tell you is that under the current system, the current system isn't working. Several countries have far better systems, whether it's notice and takedown or notice and stay down, rather than just notice and notice to protect our content. And I will take advantage of the opportunity to answer the other question too. If our copyright regime is weaker than all the countries around us, whether that's Europe or the US or whomever else we're competing with, it puts us at a disadvantage. We get fewer revenues. We have fewer independent revenues for freelancers, for our content creators, and so it puts us at a competitive disadvantage with all those around us. Thank you.
The system of notice and notice to have limits, for example, on how many times you get a notice for the same IP address for the same offense. How many notices are your members getting for offenses? Are they practically DDoSing you on these messages?
Poland is well placed to answer that because he deals with this in our firm.
So it all depends on the scale of the ISP, the number of end users that they have. That can range from a few hundred to multiple thousands into the tens of thousands and beyond. And it's directly proportionate to the number of users they have. The more users they have, the more likely it is that some users may be involved in infringing activities, and that drives the volume of notices that they might expect.
Can you enforce any kind of notice and takedown system or filtering without violating net neutrality?
I don't think so. I think that's the concern, is that without court supervision, there is a serious risk of eroding democratic values of free speech and expression, freedom of expression, and that is one of the reason we have court safeguards is because the courts are the ultimate protectors of our Constitution and our democratic values, and I think to do anything other than that isn't necessary. I also want to make the point that the notice and notice regime isn't just this tool that's out there that nobody cares about. We in our practice actually see follow-up from content owners who, when they see that there are multiple infringements from the IP address, will actually start court cases to get the information on who the users are and will pursue them. And those people are in Canada and they can be sued for statutory damages, and effective injunctions can be levied against them for infringement. There's no reason those remedies aren't available. The other thing is, although there is a safe harbor for ISPs, they're also subject to the peril that if they are deliberately and repeatedly engaged in those sorts of activities under 27(2.3) of the Copyright Act, the safe harbor doesn't apply, I would say. So it's we don't need to go very far and compromise our values to deal with this problem.
I have only about 5 seconds left.
Yes,
I want to
right.
ask one very quick request. You mentioned that you're getting notices that have things that are beyond the scope of the statute. Is it possible for you to share us at a later date examples of these letters that are sent to your users that vastly exceed the elements prescribed by statute?
Provide some redacted materials.
Thank you.
Sure.
Appreciate that.
Sure, if you can send them to the clerk, that would be great. Thank you. Mr. Albus, you got 5 minutes.
Thank you, Mr. Chair. I thank all of our witnesses for being here today. It's a fascinating subject and appreciate you all sharing your points of view. I would like to start first with Mr. Tassett. Mr. Tassett, you did in your opening statement, you talked about vertical integration, and there are a number of us that are familiar with the term, but specifically, what type of ISPs are you referring to?
Well, we're referring specifically the ones that are the biggest and have the most resources and are championing the Fair Play Coalition our
you
Bell, Rogers, Shaw, and so on. Video.
So the ones that have plays in both media creation, distribution, and also
That's right, and
also the
content,
ISP
yeah.
service.
That's right, either directly or through affiliates.
Now, you said that there was a few different options. If such a program was to be put in place, such as Fair Play has suggested, there would be costs. You did say that the state could possibly pay for it, which means the Canadian taxpayer or a certain subset. You also said that if the ISP would, again, there's some proportionality because obviously in some areas ISPs are much smaller and service very niche markets, particularly in rural areas. So the proportionality would certainly impact them more. Is that correct?
Well, it depends really more on what technological, how big their scale is and what sort of technology measure is being required of them. If, for example, you order an ISP to use deep packet inspection, which is a form of actually inspecting the headers on packets of traffic, which tells you a lot about the type of traffic that is being carried. And if that's used as a method of trying to detect infringing traffic, and we won't talk about the merits of how accurate it is or isn't, but let's assume it is, those DPI boxes can easily cost $100,000 each. So for a small ISP, you could literally put an ISP that's comprised of 2 to 4 employees out of business by requiring them to buy
especially in rural areas where there's a smaller
Wherever they
network
are.
or a very expensive network to service.
Sure.
Then, of course, the other alternative is to have the media companies that are asking for these takedowns to happen. They would do it, then it would be all on their customers. Is that correct? So
That's
inevitably, if we go down this path, there will be increased cost to consumers or to Canadian citizens or some subset
Somebody
of either.
should pay other than the person that's sort of the innocent party just being required to do the job.
Now, in regards to some of these automatic tools, I know my colleague, Mr. Lloyd, had mentioned that new technology comes across. I know a lot of younger people and some probably older people play video games where they have music in the background, and of course they generate their own content to share with other people for different games or whatnot. That kind of music being played in the background could trigger one of those automatic takedowns if that technology was. So the technology doesn't necessarily, because there are protections for satire, there's protections for individual sharing and whatnot. Those things could be put at risk as well, could they not?
Potentially, yes, because the packet inspection and making decisions on blocking based on that doesn't provide you any information about the context in which those packets are being transmitted. And
So-
you're quite right. Some of them may be authorized, some of them may not be.
So you mentioned earlier that you're ultimately, if we were to put in place that kind of system, that ultimately that ISPs would have to look in things in terms of their economic interest rather than other values. So can you give an example where an ISP might have to make a decision? And again, we are asking to basically regulate the conduct of others. And what I may suspect is might be exploitive to some. Other people would say, no, that's generated content. That's freedom. That's their content. So maybe if you could just give us a few examples of how those compare.
If in the carriage of content, the issue has come up, and by the way, there are already provisions now that, again, don't allow ISPs to take and other internet service sort of ecosystem participants to take advantage of safe harbor if there's an actual court order that says something is infringing and they're ignoring it, because then it's pretty clear that if they are participating, they shouldn't be. But in a situation where there's no legal determination to say to somebody, I think they're knowingly doing this and now I'm going to block their traffic, that's putting a common carrier in a role of a judge of what should be carried down its pipes. And that's why I'm saying that's a various danger. And if I was an ISP, I would tend to be conservative and say, well, if the penalty is very large, let's say I'm opening myself to very high statutory damages, I may be more tempted to take the risk of having the party sue me for getting it wrong because it's a smaller amount of damages than to worry, than to have to pay the large statutory damages, particularly for recurring offenses where every day is considered a new offense or whatever. So I may now start meddling in that traffic because I'm worried about my liability. We don't want common carriers to be in that situation.
Thank you.
Thank you very much. We're going to move to Mr. Bayless. You have 5 minutes.
Merci. Je vais commencer avec M. Payet.
Thank you. I'll begin with Mr. Payet. You described change legislation in Europe. If I correctly understood you, it gives collective rights management groups the right to negotiate or to sue. Could you tell us more about that, please? Yes, of course. It strengthens the management rights companies' power, and it allows them to negotiate agreements for all online content. Right now, content is uploaded by users, and we all agree that that's fine. Users can put content online. But what's going to change is that for the content uploaded by users, the platform has to pay. So YouTube will have to pay for content that's uploaded by users. So that will be negotiated. So is it negotiated or is it imposed? Well, even if it's user-generated content, there are rights that have to be respected. So they have no choice. They have to deal with rights management collectives. I see. So, but it could be. Let's say that I write a song and put it up on YouTube. I wouldn't be able to negotiate with every single person. No, it would be collective rights collectives that would deal with that. And that's what it says in the statute. Look, I think it's mentioned in the text that was adopted in Europe, but I think so. But I think in certain cases there are agreements that were negotiated. YouTube, for example, has agreements with SOCAN, but only for the part that's monetized with advertising. When the protected content is not related to advertising, then then there are no royalties given to rights holders. But of course, there is a profit motive for YouTube. YouTube does make profits off of all this. It attracts users. It organizes content. They do all kinds of things with content, but they don't pay for the content. So see, if I've correctly understood you, if YouTube wants to put up songs that are protected or that are part of whose rights are being managed by a collective, if they want to put it up on the internet, they have to pay the collective. Yes. Or they have to negotiate some kind of agreement to determine what amount that will be. Yes, and in Canada, negotiations are generally conducted through the Copyright Board to determine what the value is. That's right. Do you have anything to add, Madame Hinault? I agree with Mr. Payet's comments. That's the understanding that I have as well. And what about scriptwriters? Does it affect scriptwriters? Yes, because scriptwriters in Europe, both in Europe and in Canada, receive royalties from certain broadcasters, more particularly in Quebec anyway, through the SNCD, which is a collective rights management collective in Europe that has an office in Montreal as well, the SACD. And so scriptwriters receive royalties from certain broadcasters through the SACD, and the European directive makes us very happy because when scriptwriters' works are broadcast in Europe, they'll be compensated, but there is a lag between the European and the Canadian systems. I understand. Thank you.
On understanding a bit more about this sound recording, and you're making the argument opposite to what the musicians are making or whatever, about you're saying they're double dipping, and maybe if I could understand that you're saying that they pay for the right. What are they asking for that you don't want to give? Let me ask you that way.
So they're asking to remove from the definition of sound recording the words film soundtracks where they accompany a film. So the sound recording is sort of different from the song in the sense that a sound recording is exactly what I suggest to you. So the sound of an explosion, anything that you might find itself on the audio track of a film is a sound recording. And what the definition of sound recording does for Section 19, where it operates the way I'm describing, is it provides a stream of royalties where a sound recording that is not on a film soundtrack accompanying the film. So it's only where it accompanies the film that this exception operates. If the film soundtrack is played on the radio, for example, neighboring rights exist, royalties flow. What they're wanting to do is remove that exception. Which is to say, any time a film would be played in a theater, it would trigger royalties for everything from a sound effect to a song. And that is what we object to.
Is your concern the song or the sound effect? Because they're two different things.
Well,
if you have to pay for every sound effect, it'd be impossible to come. But let's say someone creates a beautiful song and it's used in a movie, you want to pay up front but not pay ongoing royalties? Is that what
That's currently the balance that is struck.
That's
And
what is right now.
That is what it is right now. And that's also the same for example, a dancer, for example, who choreographs a routine. That person, by the approach in the law to date has been, you can charge the rental rate up front, but you're not permitted to exercise the Remuneration Act when it's incorporated into a film. And it's a recognition of the fact that a film is a unitary work. And so that's what we object to. What we object to is the exhibitors are going to end up paying the royalty rate for every single song or sound effect or dance performance, should it extend to that is incorporated into a film. And that's what we object to.
Thank you. Back to Mr. Albus. You got 5 minutes.
Thank you. I'm going to be sharing my time with Mr. Lloyd if I can help myself, and usually I can't, but hopefully we'll get there from Mr. Lloyd. I'd like to ask Mr. Paris, just in regards to this subject of, and so I'm going to follow up on my colleague, Mr. Bayless, just in regards to it, obviously films that were filmed, close to 100 years ago, sometimes you get a case where some are remastered and now are available, reformatted for smaller screens like phones, etc. And so I just wonder how you could have it where someone would receive royalties for streaming versus, at least with your business, where you have exhibitors. They actually say, okay, I'm going to charge X amount at the door, and this is how many people saw it, so I can pay on a per basis. But for something that ends up that's going to be used in a whole bunch of different ways. So essentially, what is being asked here is to be royalties to be paid on every time a show is streamed or is shown online, or because I watched Mr. Smith Goes to Washington on Google. I think they do that as a free service, and hopefully Mr. Tassett won't have to take it down now. But if you could just maybe explain what some of those costs would work out for different platforms, such as exhibitors versus streaming.
Sure. So the section I'm referring to here, just for reference, is section 19. And you're going to test my memory here, but the section, as I recall, refers to any sort of public communication or communication of the work by telecommunication. So I don't act for a streaming service, but and I'm not a copyright lawyer by trade, but my understanding is it would apply to streaming. So in the hypothetical you're talking about with Mr. Smith Goes to Washington with his historical work, what would happen on the exhibitor side is we would pay a fee from the distributor who holds the rights to that film, and we would kick up a portion of the film rent from each per ticket sale to that person. If the exemption so that would be a public performance of when you walk into the cinema and you see it. So if you were to remove the exemption for that entitles stakeholders to neighboring rights or a royalty stream from a public performance or telecommunication of that work, our rights go beyond an obligation to the distributor, and we would end up paying a royalty to, I believe it's the maker or the performer of the recording that's incorporated into that film. And our point is the balance that's been struck in the Act to date is that once you sell your rights to include your work in a film, you're prohibited on the back end from also assuming neighboring rights, which are designed to provide compensation where the public communication of that work is out of your control. So think performance on a radio station, something like that. The record label isn't involved in obviously granting permission every time a song is played on the radio. So neighboring rights exist to provide a flow of royalty from that uncontrolled, perhaps unintended use of that work. Whereas in film, the inclusion of a song, a dance performance, an acting monologue, whatever it is very intentionally included, negotiated, and compensated up front. And so putting the burden on exhibitors to pay again, we suggest upends the balance that has served the film industry so well to date.
So I'll quickly take over, and I'll also keep on this line of questioning. How many people are currently employed by the people you represent?
Well, I can speak to Cineplex. I mean, we've got we're talking tens of thousands, right?
Okay. So with that, we're talking, if we go with the recommendations to include the sound royalty, there's the double dipping that you're talking about. does that put you at a significant competitive disadvantage to the Netflix, the Prime Videos, and those companies?
Yeah, of course, and that's a great question. I mean, we have a number of competitive disadvantages, not the least of which is that Netflix doesn't pay tax here. So there's that. There is the other added cost that Netflix doesn't necessarily pay film classification fees, and all the costs that go with operating a bricks and mortar business. The streaming services don't bear, right? So in this particular circumstance, with a royalty such as this, I suppose it would apply to exhibitors and streaming services equally, if I'm right about that. So it is one layer of additional cost, and it's one thing for large chains to deal with that cost. It's quite another thing for independent cinemas who, and I'll go back to what my colleague said about ISPs. If you're running a single screen cinema,
but it will kill jobs.
Yeah, it absolutely will kill jobs.
Thanks.
And cinemas.
We're good? Thank you very much. We're going to jump to Ms. Cesar Chavanez. You have 5 minutes.
Thank you, and I'm going to be splitting my time with Mr. Lametti, and thank you for coming. I'm going to continue the line of questioning with Mr. Paris and the line that from Mr. Lloyd in terms of what are the implications to having these royalties paid for the recordings or the tracks once they're in the exhibitor's possession or being played there. What are the implications further to the other components of the film? So if we start off with saying that these royalties need to be played, you mentioned choreography, you mentioned other components. If we go down this road, what are the implications for that to the exhibitors and beyond that to many of these organizations, some of which are mom and pop shops, some of which are single screen cinemas? What are the implications beyond that?
So, I mean, in a really short response, this would be an additional operating cost, a higher operating cost. I'm not in a position right now to tell you or quantify what that would be. We're responding to the proposal as it is now. In terms of talking about what it would be for other collectives, I can only tell you that the proposal that I'm speaking about today arises from the music industry. It doesn't come from those other things, but once you start treating one class of creators differently, it's obviously going to follow on. So I'm forecasting a little bit here. But the implications of higher operating costs will depend upon the business position of either the chain or the operator, the individual cinema operator. But what I can tell you very generally is, and one of the honorable members alluded to it earlier, is that we're all the creative, and I'm sure everyone will be unanimous here, is that the creative economy is undergoing a great deal of disruption. So, as I noted in the study from Telefilm, exhibitors are competing with streaming services, but we also compete, I would say, with every other form of out-of-home entertainment that exists: sporting events, concerts, museums, anything on your phone. So when you add additional operating costs, that's money those independent cinema operators cannot invest into the cinema itself, the theater, technology, hiring young people for their first jobs, on and on down the line.
2.5 minutes.
I think what you're all asking us to do is look at the initial positions between copyright and contract, in the sense that you're asking us to say, should the writer be paid up front in a contract, or then should the writer get additional copyright royalties later? C'est la même chose avec co-titularité.
The same thing with co-rights or jointly held rights. It's an issue we have to determine if the author is to be paid, whether it is to be compensated at the time of creation or afterwards through royalties. So, Mr. Payette, it's surprising that you don't have a position on what Mr. Adams said yesterday, because we already have. Authors already have rights under Section 14(1) of the Act, and a right that reverts 25 years after after death. But what Mr. Adams said is 25 years after the work was created. So it's very important for you to have a position on that. Don't you think so? I do have a position. Indeed, I believe it's 25 years after death. Right? That's under the current statute, yes. So I said, when they're asking for 35 years afterwards, that can be negotiated in a contract. Yes, but it does change the fundamental position, the basic position. It changes the power at the beginning, doesn't it? Well, yes, of course, but my position is clear. I don't believe it should be incorporated into the Act. If Mr. Adams wanted to recover the 35 years, to go back to 35 years, he could have done all kinds of things. He could have not dealt with a publisher. He could have had, he had several options open to him. I think what is important is not in all this debate around the statutory review is how can we get more revenues for content creators and for authors. Well, that's exactly what Mr. Adams was proposing, giving more power to authors from the beginning with a reversionary power after 25 years. Well, that's right.
You've got two.
Mr. Chair, Mr. Paris, just to kind of get a kind of summary in terms of the cost that you would be incurring. You can't quantify it from the suggestion, but also what would be the administrative elements to it as well. So just trying to quantify exactly. I know you can't put a price on it, and I'm not regardless of where the money goes. I'm just also curious about the processing, or whether that's not really a factor in all of this.
Well, in the material filed by Music Canada, I think they estimated that the cost of these additional royalties to both broadcasters and exhibitors would be something in the order of $45 million. And there's no citation provided for that number. I don't know if it's greater or less than, but that's where they ballpark it. In terms of how it would be administered, I expect what would end up is you probably have to have some sort of copyright board tariff that would be negotiated and paid. I don't know if I can speak to you into the nuts and bolts as to how that would be administered, but I can tell you I expect they would organize it in the same way other collectives enforce or govern their mandates.
Would it be fair to say that there is or is not an easy way to piggyback that new proposal on a current infrastructure in terms of administrative wise, or is it something that would require a new model?
Yeah, I don't know if I can comment on the administrative burden at all.
If I may comment, actually, cinemas are already paying rights holders, and they have deals with SOCAN. Tariff 6 says that cinemas have to pay $1.50 per seat a year to SOCAN for collective administration. So my understanding for sound recordings would be the other side. So there's the song and there's a recording of the song. They would have to pay a collective management society like Resound, for example.
Yeah, okay. Yeah, I mean, as I said, it's not news to anybody that we certainly pay tariffs to certain collectives, and I'm saying that I expect it would be organized in a very similar way, but it really would depend on which collective we're dealing with and what is actually being asked of us, right? In this particular circumstance of a sound recording, I'm guessing it would be a collective other than SOCAN and perhaps multiple collectives, but I'm guessing it would be administered in the same way. Yeah, Resound.
Thank you very much.
Thank you.
That takes us to the end of this round. We have enough time to do a second round of 3 7-minute questions. So we're going to go back to Mr. Johari.
Thank you, Mr. Chair. Thank you to the witnesses. I'll be sharing my time with Mr. Bailey's. I have one question, and that goes to Mr. Payette. I'm going to share some stat with you, and this is concern that I have regarding the stat that I looked at, and it has to do with the decrease in the median income of the musician and singers. The stat that I was looking at indicates that between 2010 to 2015, the revenue of the Canadian music publisher increased from 148.3 million to about 282 million. And over the same period, the median income of individual working full-time in the Canadian music industry increased as well. Those occupations such as producers, directors, choreographers, conductors, composers, arrangers. However, the median income of musicians and singers saw a decrease about $800 between 2010 and 2015. Can you share your thoughts with me? Why is that?
There's different role of being an author, a composer, a performer. So music publishers represent the songwriters. So if the music publisher makes more money, the songwriters also make more money. But on the global picture, it might be that there have been less shows, or the individual songwriters make less money because there are more songwriters. And the main problem is that the new environment digital environment pays less than the traditional environment. And for individual writers and composers and musicians, this is very...
Is there any amendments in the Copyright Act that you think it will be able to help improve the income situation of the musicians and singers?
Of course, having more money coming from let's say like YouTube or other online services would make life more easier for musicians and composers.
Okay, thank you.
Madame Inou, vous avez parlé de l'idée de...
Ms. Ino, you talked about the idea of script writers and directors becoming jointly holding the copyright. I'd like to understand why that is your position. Do you expect to receive more money, or is it just an issue of wanting to have it? Could you explain your reasoning in asking for this? Well, my understanding is that in terms of royalties collected by rights management collectives here and outside the country, we are penalized in Canada because the presumption of joint ownership of rights is not explicitly addressed in the law. So it weakens our position when we're trying to obtain it elsewhere in the world. And when we ask you to specify that in the Act, it's not revolutionary. It's aligned with case law, and it's also a presumption in the Act. It's just not explicitly stated. So of course we described the work that the director does on audiovisual works, as well as the scriptwriter, and it's logical that the first creators, that they are joint creators of the audiovisual work. I would say that it's a clarification that we're asking for in order to give leverage for us to collect these rights elsewhere in the world on behalf of Canadians, where there are regimes for private copying, private use copying. There, in some countries, there are colleges in which producers, interpreters, performers, authors, they all gather together, and directors too in Europe. But it also includes producers, because it's difficult to say that the producer who's going to make all kinds of choices in developing a movie, but is not an author. Well, no, the producer's not an author. The producer hires creators and authors, but the producer doesn't create anything. The producer administers the production, obtains licenses in order to produce, and so forth. And in the case of scriptwriters, the script writer will also share his revenues. For example, under the collective agreements, if there's been a script written for a television series, they're going to negotiate contracts for all kinds of aspects. And here in Canada, we don't recognize that on top of the compensation, being compensated for one's work, a content creator could also take part in the success of any particular work associated with one's content.
Listen, I think Mr. Massey was really onto one of the cruxes that I see as a concern is new deals being made in Europe and made in the United States. We could have easily a creative drain from Canada going into markets where you can actually get paid for creating product and creating works. The market isn't working in Canada. We have money being made, but it's not being made by musicians. It's not being made by creators. I think we need to look really, really carefully and maybe even accelerate our study to come up with some conclusions so that we can protect the creative class in Canada. We're creating middle-class jobs through this, but now we have either impoverished people or people that are very successful in the industry, but there's nothing in between. So the market isn't working. Just a quick comment back from any of you on whether it's publishers making money and the digital servers making money, and there's the digital companies are making a lot of money. Performers are not sharing in the benefit. So where can we go with our study to try and drill into that a little bit further?
I think, for example, music publishers share either 50% or 75% or any other, but generally it's between 50 and 75% of the revenues directly to the authors. And of course, they work for the authors, and that's what they do. And it's normal they get paid. The problem is there's not enough money getting in the system. It's not retained. It's because the digital companies make a lot of money using content, and that's the problem. And you're right that if we don't get enough copyright protection in Canada, we're in disadvantage between our other partners.
Thank you very much. We're going to move to Mr. Elvis. You have 7 minutes.
Great. Thank you, Mr. Chair. And again, thank you to all the testimony here today. One of the concerns I do have, and there are a lot, there's concerns that musicians aren't being able to provide for their families and to be able to have their rights respected. That's an important thing. But I'm also quite worried about innovation and how people can generate new content. I've heard anecdotal stories, Mr. Chair, of where someone will actually write a song, publish it on YouTube, and because YouTube has years of content that's added every single day, it's impossible for the platform itself to be able to hire enough people to be able to watch them. And so I've actually heard cases where because of these filters, it will suddenly say, sorry, you're infringing upon someone else's rights, and taking it down. And that's new original content. So obviously the technology isn't there yet. And if we look at some of the new rules that are being talked about from Europe, again, I'm worried that some of these may take down legitimate, where someone is either reviewing a piece or is generating their own content, whether it be music being played to for satire or for criticism, etc., where that gets taken down. So, again, I do see that there's a balance, but I'd like to just hear a little bit more from how do you deal with a problem like that, where the technology, specifically when you have cases where in Europe the requirements are much harder. I'm worried that these content rules will require YouTube-like applications to shut down legitimate innovation or legitimate criticism or whatnot. If I could have maybe Monsieur Payette.
Yeah, well, I think the greatest threat to Canadian creative economy is not having enough money getting in the system. And U2 has already a technological, they call it content ID system to identify the right holders. And they have taken provisions in Europe to protect smaller business or educational use of content online. So it's not threatening the innovation side. And they just need to remunerate more the content owners, and that's what we need to go forward with this. And Europe did look at that. And also, I need to point out that there has been a lot of misinformation around what happened in Europe. Google spent dozens of millions of dollars on lobbying, and there was a lot of misinformation being sent out, and the European members of parliament did look at that and finally accepted with a large majority after they understood what really was going to do the new text proposed. And it was largely adopted. Like, I think it's 429 against 232 or something like that, or 226. Wow. And I think Europe does care about freedom of speech, about innovation, but they also care about the right holders and the creative industry. That's what it's been shown.
Well, I agree that, I'd like to believe that legislators always do the right thing and vote for the right way. There is a balance, though, between, trying to establish and continue the rights of the creators, also, though, with the rights of everyday citizens and who judges. And the thing is, with Google and these automatic filters, we don't know that everyone's getting a fair shake. And some Canadians, I believe Justin Bieber got his start on YouTube. And so, I hear what you're saying. On the flip side, though, many of these rules in Europe have only come up recently. Is that correct?
Yes, and I think things are changing, and it's time that we change. But when you mention balance, when we look at digital companies and rights holders, so can published numbers. The average songwriter makes $30 a year. That's not enough money. How much does Google own, or like YouTube? There's a lot of money out there, and it's not going to creators because the balance is not fair.
I would say the two models are very different. One is set up to serve the internet in a different way, and the other one is meant to serve people that like that kind of music. So I'm going to hand it off to Mr. Lloyd for the remaining time.
Yes, I guess, my line of questioning is going to be for you as well, Monsieur Payette. You seem to be getting the brunt of the questions today, but, we talk about competitiveness issues right now. We're dealing with NAFTA, we have taxes, regulations. We're always trying to fight to make Canada a better place to invest. And we always think about that as traditional industries, but our cultural sector is also a very important and growing part of our economy. And so I guess my question is Canada a competitive place to make music, to be part of it? Is it competitive culturally? And if not, what do you think can be done to make us more competitive? And then I guess, Mr. Tassett, if you had any comments on that.
Well, I think culturally, yes, we have strong creators and we have a system that allows culture to be vibrant. But on the copyright side and the remuneration, and we have to understand that copyright is not subsidy, it's private income that's coming for the exploitation of the work. And this really brings down the competitiveness of Canada, not having enough money coming in from the digital services, not having strong legislative or other kinds of things to address copyright. The rate settings should be faster, and we have to really make changes to follow what's happening in Europe and in the States to be more competitive on the copyright
Who is
side.
benefiting from our lack of competitiveness? Who are the chief benefactors of our lack of competitiveness with copyright?
Oh, the benefiters of the weak copyright are the users, and mainly right now the online platforms,
and
digital
Mr.
companies.
Tassett, do you have any comment about that from the perspective of smaller ISPs? Like, are they competitive in Canada? Is it competitive right now?
Oh,
for
you don't
ISPs?
want to open that debate now. I know there's not enough time left. But we actually just participated in a Competition Bureau market study and discussed all of the severe problems that anti-competitive problems that exist in Canada for the smaller ISP sector. And I don't want to take us off track, but I'd be happy to share that with you or anyone else who wants it. But there are significant structural barriers to competition.
And related to copyright directly?
Well, I don't know about that. I think the competition generally. I don't want to stray into other areas that I know less about and are not my domain, but all I can say is this: if there's any kind of rebalancing that needs to take place in the digital era between streamers or those who provide content on a digital platform or whatever, that's great and fine, and this committee should make those recommendations because the times are changing. What I don't want to see compromised, because it is also a fundamental part of our competitiveness as a nation, is the rule of law. We are very much a country founded on the rule of law, where we take individual rights very seriously, and people do come to this country and have come in droves recently because of that. And so anything that we do to weaken that is going to also affect our competitiveness adversely.
Thank you very much. Mr. Massey, you have 7 minutes.
Thank you, Mr. Chair, and I'm tempted, but I'm not going to take the bait. The parliamentary secretary, Mr. Lametti, knows my position on notice and takedown, and I don't need my blood pressure to go up at the moment with regards to that. Yeah, exactly. But I do want to make a point, though, is that we have had several interventions about issues on YouTube, and I don't want to be seen as picking on something, but I want to create at least a alternative perspective. And it was raised about, Justin Bieber got his start on YouTube, but the reality is that YouTube did very well financially from that relationship as well, too. In fact, you go to YouTube right now and it has a burger on it from a chain food that they're advertising on it, and they got Fortnite and other things. YouTube has done very well through its relationship with those that have actually had some success with its platform by posting your stuff. As in many places, it's a public risk putting some of your stuff up on YouTube, and people should think about that. But I do want to actually offer, though, a chance to where we're at now is this committee is reviewing a 5-year change. We are going to make recommendations to the minister if we agree as a committee. That hasn't been decided yet, but that's really the extent of what's happening here. No legislation has been actually proposed. That would actually take the minister coming back, first of all, answering this committee, if he so chooses to do so. There is a statutory time frame for that. Then there also can be an extension that could actually run us quite late. And then on top of that, there would have to be then perhaps specific instructions to Parliament if the Act would be amended either by tabling in the House of Commons, and it would actually then have to go through a series of legislative processes eventually to get to the Senate and then passed. So there is quite a distance here to get, and there's different ways to get to that distance. But I want to leave it maybe to, if you have comments about what takes place or priorities, or what do you think if, say, for example, if we do nothing, and that could be the end result for basically the 2019, 2020. That's a reality that's out there with regards to the current act that's in place. And your thoughts on that, and if you have any, but I think that it needs to be something that's stated, especially given we've seen what's happening in Europe and the United States as of yesterday.
I'll just get it out of the way very quickly. On the sole issue that I'm talking about, the definition of sound recording, we're quite content and in favor of the committee leaving it undisturbed.
Okay. No, that's fair. That's what I'm looking for. Yeah.
I just have one comment. Motion isn't always progress. Just because things are being done doesn't mean they're the right things. And I think we as a country have to figure out what's right for our country to do overall. And we have to balance a whole bunch of rights and work within the framework that we have.
Moi, je l'ai dit, je crois que les
As I said, I think that the provision on those Canadian Safe Harbor provisions,
companies operating under the Canadian Safe Harbors right now, and the digital platforms are some of them that we and Europe has moved on this. So that's one. And I think private copying is very something important. That there was a system that was bringing in $40 million every year, and just because the law was not technologically neutral, now we have only a few millions remaining. So that's 2 points really to focus on.
Je pense que
I think that it's fundamental in order to encourage innovation that compensation follow. For our most talented scriptwriters who write television series, who get up at 6 in the morning and finish at 10 o'clock at night, in order to provide audio-visual content that are widely listened to in French Canada, are less and less compensated, even though their televised series are being increasingly broadcast. So to encourage them to continue, we have to change things. Otherwise, our children will not want to do this kind of work, nor will their parents. And I would say that in sectors where compensation doesn't follow, nor does talent follow. As Jérôme was mentioning, it is important that the values transfer that took place, not so much for our local broadcasters, but for foreign broadcasters, the GAFAs, for example, that are FANGs, that are monetizing our cultural content enormously. We have to make it more equitable. It's not going to be good for our innovation, for our creative content, for the tourism that means for the country, for all the economic benefits for Canada. Yes, culture is economic, but it's also fundamentally important to preserve it. I believe we have the economic responsibility to ensure that we still have talented creators who will agree to remain in Canada and continue to create.
Fortnight, if those members of Parliament aren't familiar with it, please let me know when you're going online so that I can teach you. Thank you.
Okay. On that note, I would like to thank our guests for coming in today and sharing with us their experiences and their knowledge. Obviously, this is a large, complex file, and we still have a lot of work to do ahead of us. But all of these questions are good, hard questions because we need to be able to get information out. That's what's going to help us write this report. So, as they say in the movie industry, that's a wrap. We're adjourned for the day.